3, 2, 1.
Oh yay, oh yay, oh yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Welcome to the February docket of the Western Section of Court of Criminal Appeals. The panel today is Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I'm Kelly Thomas from Maryville. I appreciate all the work that our Supreme Court Clerk Jim Hivner has done, as well as that of Nick Morgan and Barbara Peck. This is not as simple as just walking into the courtroom and sitting down in open court and having arguments. So thank you all very much. Each side will have 20 minutes. If the appellant wishes to reserve any rebuttal time, please tell me when you begin your argument. I'll give you a warning when you're 2 minutes away from encroaching on that time or 2 minutes away from your total time for the appellee. Do we have any special matters this morning, Mr. Clerk?
No, Your Honor.
If not, call the first case, please.
State of Tennessee versus Jamauri Ransom.
Good morning, Your
Right,
Honors.
on behalf of the appellant.
Good morning, Your Honors. May it please the court. My name is Patrick Rader, and I'm with the Appellate Division of the Public Defenders Conference. I'm here representing the appellant in this case, Mr. Jamauri Ransom. With the court's permission, I'd like to request 3 minutes for rebuttal.
3 minutes, okay.
Thank you, Your Honor. We're here appealing Mr. Ransom's first-degree felony murder conviction in perpetration of aggravated robbery. Circumstances surrounding this case will be important to my legal arguments today, so I'd like to briefly touch on the facts. At the crux of this case is a drug deal gone wrong. Essentially, Mr. Ransom was in the back seat of a car, a Nissan, with the driver and one other passenger in the front seat. After being solicited to purchase marijuana, Mr. Ransom and his 2 acquaintances met a drug dealer named Mr. Miller in the parking lot of a Marathon gas station. Mr. Miller arrived at that gas station with his friend Kevin Minter in a Hyundai. Mr. Miller got in the back seat of the Nissan, Mr. Ransom, where he claimed Mr. Ransom pointed a gun at him and took his marijuana. After some conversation, Mr. Miller exited the vehicle, the Nissan, and his friend Kevin Minter got out of the Hyundai and pointed a gun at Mr. Ransom and his 2 acquaintances. Kevin Minter then fired his gun at Mr. Ransom and his 2 acquaintances, and at least once, and in response, Mr. Ransom fired several shots, which resulted in Mr. Minter's death. So we're asking this court find that felony murder was an inapplicable charge and conviction considering the facts of this case. And we would argue that while Mr. Ransom may have committed aggravated robbery, that this doesn't really meet the standard of felony murder, and that the second act, the killing of Mr. Minter, was a distinct, separate act.
Mr. Rader, you're asking this court to basically go against our prevailing law at this point, correct?
No, Your Honor. I would say we're not asking the court to change the Tennessee Supreme Court's. I guess you're referring to the longstanding rule that felony murder may be applicable whether the killing happens before, during, or after the completion of the felony.
Well, clearly this all happened at the same time, within seconds of the drug transaction, whether that was successful or not. It all happened within seconds of each other. And it was all related. It was all part of the res gestae, correct?
Well, no, I would argue that it was divided. It was the killing from. Sorry, what was that, Your Honor?
I said, how so? Can you point to me what facts show that it was divided?
Well, the fact that the robbery had been completed and that Mr. Miller exited the vehicle to safety. He relinquished the marijuana. The robbery had been complete, which robbery is complete at the taking of the property. At this point, the state claims in its brief that Mr. Minter was intervening to help his friend. But at this point, Mr. Miller was already to safety, and Mr. Minter was engaging in a new act.
Mr. Minter saw the drug transaction, correct? He saw what was going on in the car from the other car, from that vantage point. He saw that the defendant was robbing the victim's cohort, because they were selling drugs. The facts that I understand it from the briefs, they were selling drugs that day. They were engaged in drug sales, correct? And the victim actually observed the robbery, correct?
Mr. Miller says that he believed Mr. Minter observed the robbery. Other than that, there is no.
That's the proof at trial, correct?
That was the proof, yes, Your Honor. But even if Mr. Minter had observed the robbery had already been completed, that doesn't justify Mr. Minter then pointing a gun at two innocent bystanders and my client, Mr. Ransom. Essentially, this is a new.
The defendant was, I guess, attempting to use violence to flee, which again, this court and the Supreme Court has said repeatedly that constitutes felony murder. How do you get around that?
Well, Your Honor, the rule is that the killing after the completion of a felony may constitute, depending on the circumstances, felony murder. And what we have done is we've looked at all these aggravated robbery cases in which this court and the Supreme Court have held that there's a separation between the taking of the property and the assault that happens thereafter.
Those cases, like take Swift, for example, which is the one you rely on the most. And, the violence occurred, you're correct. The violence occurred after the theft was completed. Here, I think maybe in a sense, Judge McMullen was kind of hinting to this. Your client introduced the violence when he pulled a gun during the middle of the robbery. So the violence was already there. There is no intervening circumstance like in Swift where the guy takes the PlayStation game and sticks it in his pocket and then tries to leave the store. And when they stop him, he introduces the violence by pulling a knife. There's violence from the beginning of the drug transaction, so to speak, until your client kills somebody. So, to me, that's textbook law school 101 felony murder.
Yes, Your Honor. I understand what you're saying. I think those cases also, I think Mr. Ransom may have introduced the violence against Mr. Miller, but there was substantial evidence that Mr. Minter was a bystander to this.
No, there wasn't. I don't see where your brief injected that Mr. Minter was a bystander. There was no proof at trial indicating that he was a bystander. And even if there was, we have case law showing that even if bystanders are, killed as a result of the violence in the felony murder, it still constitutes felony murder. I don't see how you're getting around that.
Well, even if this court disagrees that those aggravated robbery cases aren't applicable to this case by analogy, which is what I've argued in my brief, is that by analogy they're similar. I still think there was evidence to suggest that there was a break in the circumstances, and you even see this. The state and the trial court kind of tacitly acknowledge this with the self-defense instruction. So self-defense is completely inapplicable to felony murder. And yet the trial court and the state agreed that a self-defense instruction should be given. And in volume 3, I think on page 174, the trial court even says, all the defense has to do is slightly raise self-defense. And he goes on to say, here, Mr. Ransom certainly did that. So I think that
get an instruction for the jury. That's different. That's completely different when you're talking about felony murder. I don't see where you're going with this. There was enough to raise the inference to get the instruction, which he's entitled to. But clearly the jury rejected that in finding him guilty of felony murder.
If Mr. Ransom was only indicted on felony murder, and that was the only real charge, he wasn't alternatively, charged with premeditated first-degree murder, then a self-defense instruction should have never been given unless the trial court in the state agreed that there might have been a separation that the jury could have inferred or decided on. And so I think with these circumstances, you have the robbery completed. You have two innocent bystanders in the car who have nothing to do with the robbery. Mr. Minter intervenes after the robbery is completed. This kind of takes on a new nature, and it becomes a new act in which Mr. Ransom felt compelled to defend himself and his two cohorts. So I think if you look at it that way, then I think there is a separation between the robbery and the killing of Mr. Minter. And just to go back to our argument about the continuous offense theory and this court's rejection of that, if felony murder, well, let me just go back to the aggravated robbery cases. In the aggravated robbery cases, you have several cases where this court has held that the violence that happens after the taking is complete does not elevate that crime. And so we would argue that the taking of the marijuana acted as a break in the circumstances because the property was already taken.
So under your theory, then, you can never have a felony murder if I complete the underlying felony before I kill you.
For robbery, we would argue that if you look at all these robbery, even with the felony murder robbery cases, in those circumstances, they almost always, at least the cases I have found, they all take place before or contemporaneous to the robbery. And this would complement the aggravated robbery cases.
So piggybacking on Judge Dyer's comment, as a practical matter, you're just proposing that they be charged with second-degree murder rather than felony murder?
Yes, Your Honor. And so if the court agrees with my argument about how felony murder was inapplicable, and then we get to self-defense. And so the court should ultimately reverse his conviction of first-degree murder because he was acting in self-defense. And although the jury was left to decide this issue at trial, this court gets to review the jury's decision to reject Mr. Ransom's claim of self-defense. And in order to prevail on that claim, Mr. Ransom just has to show that the evidence relative to the justification, such as self-defense, raises as a matter of law a reasonable doubt. And I think here there certainly was a reasonable doubt about the legality of Mr. Ransom's actions. So, of course, we go back to the robbery being completed. Mr. Miller was no longer in danger, and yet his friend, Mr. Minter, takes it upon himself to vindicate his friend by pointing his gun at Mr. Ransom and two other innocent parties.
I just am fascinated. I appreciate the novelty of your argument, but you are completely mischaracterizing the facts in this case. As I read the briefs, these things, nobody was safe. This was happening within a matter of seconds that the individual who was in the car, get the name, was trying to get away from the defendant who had pulled a gun on him. As he was trying to get out of the car is when the victim was coming forward with his gun. All of these things were unfolding in a matter of seconds, and you are repeatedly inserting these gaps in the events. And I take issue with that because this unfolded within seconds. Within seconds is what the briefs tell us. So So I just caution you to be careful with mischaracterizing the facts to fit your argument.
Yes, Your Honor. I don't mean to mischaracterize the facts, and it is admittedly a novel argument. But if you do, there is evidence that, if you look at Mr. Harris's testimony on page 72 and 73 of Volume 3, he clearly thinks the offender in that case is Mr. Minter. He's scared for his life, and that's the first gun he sees. So there is evidence that Mr. Minter was reinitiated the attack on Mr. Ransom and Mr. Harris and Mr. House. And I think if you do watch the video, you're right, it is within seconds. But Mr. Miller does exit the vehicle either before or simultaneously to Mr. Minter getting out of the Hyundai.
What's the proof as to where Mr. Miller was when the shooting started, if any, other than he was trying to get out of the car?
I think the video shows that Mr. Miller is already out of the car when the shooting happens, and that he is behind the Nissan and kind of in front of the Hyundai.
Which you contend was a place of relative safety.
Yes, Your Honor. And so, for those reasons, we would argue that Mr. Ransom was justified in defending himself and his two acquaintances. And so we would respectfully ask this court to reverse Mr. Ransom's conviction of first-degree murder because felony murder was inapplicable and that he acted in self-defense. And in the alternative, if this court finds that felony murder was an inapplicable conviction, yet disagrees on the self-defense aspect, then remand it for a new trial on the lesser included. But I'll save the rest of my argument for rebuttal. Thank you, Your Honor.
You have your rebuttal time left. On behalf of the appellee.
Morning. May it please the court. Catherine Decker representing the state of Tennessee. The evidence was sufficient to support the defendant's conviction for felony murder. I think we're pretty clear about what the law is, but I'm just going to respond to one statement that Mr. Rader just made, and that is that the taking of the marijuana acted as a break, and therefore this isn't felony murder. Thacker from the Tennessee Supreme Court has laid out the law that this court follows and has stated that the murder can take place after the felony. And as Mr. Rader has said, that he hasn't found cases where the murder took place after the aggravated robbery and has been held up, and felony murder has been upheld. But even in my brief, I have cited the State v. Sweat case, and actually Mr. Rader cites it in his own brief, where that's exactly what happened. There was an aggravated burglary that took place. The defendant left the person's apartment, was confronted by someone later, a different victim actually, at the entrance to the apartment complex, shot that person and was convicted of felony murder. So, of course, following Thacker and even with Sweat as one of possibly many, I don't know, examples of when the murder takes place after the underlying felony murder is appropriate in this case, and that is the law. This is a classic case of felony murder where the defendant kills a witness to an underlying felony who has attempted to intervene in that felony. Mr. Rader has looked at the evidence and presented it in a way that he might have argued to the jury, but he has overlooked the appropriate standard of review, which is viewing the evidence in the light most favorable to the state, deferring to credibility findings that the jury would have made, and deferring to the jury's resolution of any conflicting testimony. So with that in mind, there was ample evidence that the aggravated robbery of Mr. Miller and the killing of Mr. Minter, which occurred 3 seconds after Mr. Minter attempted to intervene in that robbery, were interrelated, continuous transactions, and there was a causal connection between the two. To appreciate the close physical proximity between the aggravated robbery and the killing, it's good to review the facts again. As Mr. Rader has stated, these people came to a gas station in Jackson, 2 separate cars. They parked, by the way, near the gas pumps, right? And you can see in the video that it's a fairly well-lit area. They parked facing each other, side by passenger side to passenger side. Mr. Minter is in the front passenger seat of the darker Hyundai that you see. The defendant is in the back passenger seat of the white Nissan. So Mr. Minter is within feet of the defendant and facing that direction. Mr. Miller got out of the car, got into the Nissan, where the defendant had scales to measure the marijuana that Mr. Miller was going to sell to him. According to Mr. Miller's testimony, the defendant then pulled a gun out, said he was going to shoot Mr. Miller, and Mr. Miller put his hands up. He tried to grab back the marijuana and exited the Nissan when the marijuana fell in the car, so he exited. You can see, well, according to Mr. Miller's testimony, Mr. Minter could see the robbery. And viewing that evidence in the light most favorable to the state, that's what we have to, that's the evidence that we consider here. To answer Judge Thomas's question, Mr. Miller got out of the Nissan at the same time that Mr. Minter got out of the Hyundai and was running away, but it was 3 seconds later that he was killed. So whether it's not as if Mr. Minter knew Mr. Miller was safe. This happened simultaneously. Defendant shot and killed, as I said, killed Mr. Minter 3 seconds after he got out of the car, and then he fled first to Memphis and then to Mississippi. In fact, the door to the Nissan is still open when he's shooting and as they're fleeing. From this evidence, it was perfectly rational for a juror to conclude that Mr. Minter witnessed the robbery, that Mr. Minter attempted to intervene in the robbery, and that the defendant killed him when he attempted to intervene. And it was rational for them to conclude, therefore, that the robbery and the killing were interrelated and causally connected. And the evidence.
Counsel, I mean, I think we get, what the facts are in this case. But are we just talking about apples and oranges when we talk about the felony murder rule and the rule in SWIFT that basically when it comes to thefts and derivative offenses of theft, that the taking is complete or the offense is complete upon the taking? Can you genuinely speak to that? Because you've got to give the defendant some credit for this argument, because it does seem somewhat inconsistent.
It is apples and oranges, Your Honor. The rule behind and first of all, we don't even have to get into the policy considerations, because the Tennessee Supreme Court has told us what the law is. So until the Tennessee Supreme Court changes Thacker, that is the law. But if you just want to step back and look, yes, absolutely, it's apples and oranges. The felony murder, yes. So, just for fun last night, I reviewed a law review article about the felony murder statutes. The purpose behind that is just completely different. It is completely apples and oranges. This is not just teeing up the Tennessee Supreme Court to have them change this long-standing 50-state policy behind the felony murder statute to make it consistent with the other statutes. That is not what we have here. I just do want to address, though, the argument that Mr. Minter, that there was a break because Mr. Minter, according to Mr. Rader, got out of the car shooting his gun. And I do want to make a correction on page 20 of my brief where I say there was no evidence that Mr. Minter initiated the gunfight. I should have said there's no credible evidence, referring to my later argument on self-defense. But in his police statement, the defendant says, I didn't even have my gun out. My gun was in the backpack. Mr. Minter came out shooting first, and then I had to retrieve my gun. But the jury has already ruled, they've already determined this fact against the defendant. That it was within the jury's right to find this statement not credible. And I will get to that when I talk about the self-defense in a second. And it was in the jury's right to find other evidence credible and other evidence that it was not as if, and this would be consistent with what the defendant is saying, Mr. Minter randomly, without seeing any gun, without knowing that there was a robbery, that he just popped out of the car and started shooting at the defendant. The jury was able, it was within the jury's prerogative to find that not credible. And so, again, according to the correct standard of review, we view the evidence in the light most favorable to the state, and we defer to those credibility findings, and that argument must be rejected. And again, the evidence was sufficient. I'd like to turn, unless you have any further questions on the sufficiency claim, I'd like to turn briefly to self-defense. Again, it was within the jury's prerogative to reject the defendant's claim of self-defense. And properly viewing the evidence in light most favorable to the state, the evidence sufficiently supported the jury's rejection of that defense. I've argued in my brief that there are reasons for the jury had to concluded that certain of the defendant's actions exhibited a consciousness of guilt. And I can talk about those. First, flight. The jury was instructed that that they could consider the defendant's flight as a consciousness of guilt, and certainly he testified and admitted that he left the scene first to go to Memphis and then to Mississippi, where he took the murder weapon with him, and that's where he was arrested. There's a second reason too, which I can get to if you have questions about it, as why his lying. The jury could determine that he lied in his statement of fact, and the fact that in his statement to the police, and the fact that he lied, also they can view as a consciousness of guilt because he lied about when he got the murder weapon out. But most significantly, the jury was rationally rejected the claim of self-defense because a person is not justified in using self-defense if he provoked the other's use of self-defense. And here, the evidence sufficiently established that the defendant provoked Mr. Minter's use of self-defense. As Mr. Miller testified that Mr. Minter was able to see the robbery and was able to see him being robbed at gunpoint. And not only would he have seen the gun coming out, but he would have seen Mr. Miller throwing up his hands. The jury could rationally have found that when the defendant pulled his gun out and pointed it at Mr. Miller, that was a life-threatening act against Mr. Miller, and that provoked Mr. Minter to get out of his car with his gun drawn. And for that reason, the jury was justified in rejecting the self-defense claim. Unless you have any further questions, I will rely on my brief for the remainder of my arguments, and I will just ask the court to affirm the defendant's conviction for felony murder.
Thank you. You have 3 minutes of rebuttal time.
Thank you, Your Honor. I just wanted to clear up a few things that the state addressed in its argument. First is I want to make clear that I'm not asking this court to modify any rule that the Supreme Court has laid down. The Supreme Court has only said that killing that occurs after the completion of a felony may constitute felony murder. I'm not saying that just because it happened after the completion of the taking, that it can never constitute felony murder. And the state cited State v. Sweat, which we both cited in our briefs, but that is a burglary case, not a robbery case. And the court's rejection of the continuous offense theory, I think, was only as to robbery cases. So that's one clarification. And then as for the consciousness of guilt, we aren't, saying that Mr. Ransom isn't guilty of aggravated robbery or maybe even a lesser included. But what we are arguing is that felony murder wasn't an applicable or an appropriate charge or conviction in this case. And again, I think that's highlighted by the trial court in the states. They felt that self-defense could be viable, whereas if it were truly a felony murder, self-defense instruction should have never been given. And with that, Your Honors, we're asking that this court again just reverse Mr. Ransom's felony murder conviction, and we rely on our briefs. And if the court finds that it agrees with us on the felony murder argument, but not the self-defense argument, then we would ask this court to remand for a new trial on the lesser included offenses of first-degree murder. Thank you, Your Honors.
Thank you. Appreciate your arguments. Mr. Clerk,
Now in recess.
Yes.
This honorable court is now in recess until 10 a.m.
Thank you.
Thank you, Your Honors.
Thank you.
Thank you.